Hi, so this is submission number 62. Our paper is titled Algorithmic Governance in the Security Context, and the authors are Kelly Blount and PJ Blount. First, we should note that this research is made possible by a doctoral research grant and an industrial fellowship grant from the Luxembourg National Research Fund.
Individuals create massive amounts of data that is collected, processed, stored by various actors for lots of different purposes. This is very interesting to us because data is fungible and it's mobile and it's networked. And this makes it very, very powerful. It traverses not just geographic space, and that means borders, which we'll talk about the second part of this paper, but also digital space. Because of the sheer amount of this data and the fact that it is in fact networked, AI, artificial intelligence, and machine learning are increasingly being used to process the data and to automate decision-making functions, or here, judgments. The judgments can be implemented into different governance structures, which raises issues related to the balance between the governing and the governed. The first part of this paper will talk about criminal justice and law enforcement. And there's a very important balance that we look at between the individual, the citizen, and the police or the state. And the stakes are particularly high in this scenario, in which judgments can be used for enforcement, they can be used for making decisions as regards punishment, and the like. The paper takes a Janus-based approach to analyzing how this data explosion changes the balance between both enforcement and individual rights, domestically, which is the first part of this paper, which I will talk about, and transnationally, which is the second part of this paper. In the domestic context, and here again we're talking about law enforcement and criminal justice, we think about public security as one of the core goods that's provided by the state. This can take the form of crime control, but it can also take the form of protection against public health crises, which obviously we're all very aware of. And so in the context of policing specifically, security is counterbalanced with the rights of individuals, as I've already said. And this balance is most often achieved through procedural mechanisms that both set the rules for the state for a trial process, for criminal justice processes such as stops and searches, but it also protects the individual. We call this due process. In criminal justice, due process is very important because we're thinking about the deprivation of liberty of individuals as well as public safety. And so we're balancing the interests of the community, this public safety, the safety of individual citizens and their homes and their families, versus the right of an individual. Someone should not be treated as guilty or should not suffer a deprivation of liberty because the state arbitrarily or incorrectly decides that they are in fact guilty of a crime. In talking about domestic law enforcement and criminal justice, there are two areas I want to focus on: policing and trial processes. In policing, there's a very clear entry point in which an individual is introduced to the criminal justice system. Obviously, this can take different forms. It can be a stop by police, it can be a search of someone's home, it can be intake as a witness to a crime or a victim. And so technology and AI, which I'm talking about here, can be used for policing in terms of patrols, of predictive policing, guiding patrols, collecting of evidence, creating criminal profiles. Pretty much anything that police do can be enhanced by the use of artificial intelligence or similar technologies. Similarly, in the court system, algorithms are regularly used in prosecution of criminal offenses. Two of the big ones that I think we're most familiar with are the setting of bail and sentencing. For the setting of bail, judges might use a risk assessment to determine whether an offender, an alleged offender, is likely to reoffend or to be a flight risk, and that means to not show up for their trial. And so obviously a judge would like to know whether or not bail should be set above a certain point or whether bail is even feasible in countries that use bail, or protective custody should be done. Similarly, in sentencing, a judge wants to know what the risk is that an individual may reoffend or be a risk to the community. Often these might take the same form. These tools, often used by judges, come in the form of an algorithmic risk assessment. There are many different ways in which AI is used in the criminal justice system, As is machine learning or other types of technology, they do not necessarily also include AI and machine learning. But here we're talking about risk assessments that perform very advanced algorithms to bring together a number of factors to produce a probability that something will or will not occur. There are certain characteristics for these risk assessments that may give us pause when we're talking about something as important as criminal justice. One of the first issues is a lack of transparency. This is the case not just with the underlying data, which is often quite problematic in that it is not collected uniformly, it is not recorded uniformly, and it may reflect policing bias, as well as the transparency of the AI. Most police officers and judges do not understand how the algorithm functions, nor can they, as they're not often available. Second, another characteristic is that these algorithms use data that are reflective of policing, not necessarily crime. And so crimes that are reported or called in, or officers who make stops, not necessarily are doing so every time a crime is committed. There are crimes that aren't reported. Similarly, policing may take a certain pattern, which is where bias comes in. And so this data is reflecting things, the data that is collected or recorded. It's not necessarily accurately reflecting the crime itself. Third, these types of assessments create a self-perpetuating cycle. What I mean by this is that particularly in policing, when risk assessments are used, they generate a probability based on what has been done in the past. And therefore, if an individual is stopped by the police, they will feed into a profile that makes it more likely they will be stopped again in the future. This comes in to the fourth characteristic, the amplification of biases. If policing is done in a biased manner, these algorithms are trained in such a way that these biases become expected and a part of the program, and therefore any new information that will be fed into the system will be viewed by the algorithm through these biased lens. This means that if policing behavior, and again, this is not necessarily crime, it's policing behavior, is biased, the predictions that come through a risk assessment will also most likely be biased. This is also present in courtroom procedures. For instance, if we're looking at the setting of bail, when previous data that are collected are biased or incomplete or inaccurate in some way, the individual whose bail or custody is being determined will also be viewed in the same biased manner. I've just outlined some of the issues that arise from a practical standpoint with this type of risk assessment. However, when we're in the criminal justice paradigm, we need to look at the legal implications. As I mentioned at the beginning of this presentation, these protections take the form of due process. In criminal justice, there are several particular due process rights that we are very, very concerned with. These apply in both policing and in the courtroom to different degrees or different situations. The first one is the presumption of innocence. The presumption of innocence can take many different interpretations, some much more strict, as in the United States, which is a common law system and uses an adversarial trial process. In the European model, the presumption of innocence might be stretched a bit more broadly and is not necessarily a trial process as strictly defined. The presumption of innocence may be impinged in several very obvious ways. Returning to the example of policing that relies on crime data as recorded by police, we may see an uptick in individuals who have previously been stopped or previously incarcerated or previously arrested and later acquitted or not even charged due to the fact that they are now in this record-keeping system. Many predictive policing software do not distinguish between arrest data from conviction data or any of the in-between status. Therefore, an individual who may be arrested or stopped on suspicion of a crime and later released, or an individual who very similarly may be stopped or arrested on suspicion of a crime, charged and then acquitted, or even just not found guilty for any number of reasons, should be presumed to be innocent. In the European model, an acquittal or no finding of guilty means that one is to be presumed innocent, then moving forward. If police may use this data to build a suspicion, this will de facto be a violation of the presumption of innocence. Similarly, the reasonable suspicion standard, which really plays only into policing for the purposes of this presentation, requires that a police officer must have a reasonable suspicion, and depending on the jurisdiction, this might be defined somewhat differently, but this suspicion is generated based on the officer's knowledge and awareness of the situation. The situation takes into account the full context, the time of day, what he or she observes, what he or she knows about the situation, and based on this, they may form a reasonable suspicion. It is very questionable to what degree an individual may form an authentic or genuine suspicion when they have the output of a risk assessment. This may cause them to believe they are in an area where they are at a higher likelihood of particular crimes, based on information they cannot see and they cannot question, and which may be inaccurate. Therefore, behavior that they observe may seem suspicious when in fact they are looking for an individual who might fit the particular profile of a criminal type in a criminal area, quote unquote. Therefore, I would argue that the reasonable suspicion standard cannot be fully used in its original intention with this type of software. The next legal issue that arises is non-discrimination, if you're in the European context, and I'm referring specifically to the European Convention on Human Rights, or equal protection under the law in the US system. As I've mentioned, bias will be inherent in any information or data that's collected by humans, even if it is not knowing or purposeful. Even if an algorithm is able to anonymize data, it is well documented that algorithms with machine learning capabilities are very strong to the point that they can unanonymize data and infer connections. Therefore, any biased policing on account of ethnicity, race, socioeconomic status, or the like may be inferred by machine learning, even if purposely left out. And therefore, it is very difficult to put together a predictive profile without allowing these biases to also flow through. The next legal issue pertains to the courtroom. It is the right of a defendant to challenge evidence against him or her. This means they must be able to be aware of the evidence. They must have the opportunity to challenge it. And for any of these things to happen, it must be accessible. In the case of risk assessments and algorithmic profiling, it is very difficult to understand the process. It is near impossible to collect the data that is used for it. And even in a situation in which an individual would be able to access this data, to view this data, or to understand this data, it is often prohibitive in terms of expert witness or even the ability of the judge or counsel to understand themselves. Therefore, it is virtually impossible to use this type of information when it's included in evidence. And finally, the right to a non-automated decision-making. This very much is within the ECHR context, in which an individual has the right to decisions regarding their own legal rights with a human involvement. Therefore, even if predictive policing or sentencing by algorithmic processing is allowed, it is important that humans are able to be a part of the decision-making process, not just to the extent that they can override the decision, but that they can understand the way in which it is generated. Each of these examples that I've given are based on how these types of risk assessments generally function. It is not to say that it is impossible to use these risk assessments in criminal justice. However, it is very difficult in the current state of use to see how they align with our existing criminal justice framework. And going back to the beginning of my presentation, the balance between the police or the state and the individual in the community is very much skewed. This is already being done in many places. In the terms of predictive policing, there are two types of policing that use this type of technology. One is particularly worrying in that it profiles individuals to identify them and seek them out to ensure that they individually do not commit crimes. One is the London Gang Matrix. The second one is the Chicago Strategic Subjects List. Both of these use a number of categories of data to inform police officers who they should be watching very closely. Depending on the use or the situation, it can be more or less acute. The Chicago Strategic Subjects List, SSL, for instance, which has since been discontinued, would inform officers of individuals who were considered to be high risk of offending or becoming a victim to engage with these individuals in any way necessary. This would mean following them, sending them letters, coming to their door, and warning them that if they in fact were to commit a crime, they would receive a much harsher penalty. In the courtroom, there are similar programs. One of the most famous is Compass in the US, which was made very popular or very well known with the Loomis case in Wisconsin recently. And the second one is HART out of the United Kingdom, which stands for Harm Assessment Risk Tool. HART is very similar to Compass in the US in that it would assess an individual's dangerousness, quote unquote, to determine whether or not they would be eligible for rehabilitation. So similar to setting bail or determining punishment, it was to determine whether or not this individual would pose a harm to the community. And so again, balancing the risk of community versus individual rights, but giving the state very, very enhanced power to make that decision.
So thus far we've been talking about this in the domestic policing context, how policing functions use data and AI to make judgments that are then implemented into enforcement decisions. Now, one of our core observations is that national security is very much linked to this same security good that is provided by the state in its policing function. Now, the goal is oriented externally outside the borders rather than domestically, but the good itself is the same. Now, states collect foreign intelligence and they process it to protect against these external threats to the security of the state. Now, this can be an automated risk assessment process that's very similar to that seen in the domestic context. And I think that's an important observation, as it shows that the core activity itself, the collection of data, the storage of data, and the processing of data in order to make decisions about that data are very much the same. Right? Now, this is very much what is being done in the domestic sense, but in the transnational context, the same protections of an individual do not exist. The state is the mediator of both civil rights and human rights in the international sphere. So one of the things that we can see is that if you approach international human rights law, you'll find that while it is very good at enumerating rights that individuals and humans are supposed to have, it is very bad at adopting a standard level of treatment of those rights. And states become the entity that mediates the rights of their citizens. So while we may have an international right to a freedom of conscience as a human right, that right to a freedom of conscience is actually quite lumpy as we move across state borders, in that it is defined differently in different states. And so what this means is that when we turn our attention to the rights that are involved in the processing of data for enforcement or security purposes, that the state is still the mediator here, and that there is no supranational power that can come and change the way that the state is doing this. And what this also means is that when a state exerts this power outside of its borders, it is actually mediating the rights of individuals that are outside the borders. So what we do know is that there are numerous programs from states that engage in mass surveillance and essentially the extraterritorial enforcement processes that implicate the rights of individuals beyond the state. If we think about this in the domestic context, the rights that were discussed and are being impinged in the domestic context are still there. Those rights still exist, but they are inadequate to protecting individuals from external state power. So rights like the presumption of innocence or the reasonable suspicion standard or anti-discrimination and equal protection fall silent. Rather than a presumption of innocence, what we have is actually a presumption of a lack of rights. Now, I'm going to illustrate this with two examples here. The first is this idea of the law enforcement power of a state being focused externally, right? Because we do have two different things happening, right? Law enforcement is one thing and foreign intelligence is another thing, despite the fact that the underlying activity is the same. But we do see law enforcement often focusing its attention outside the borders of the state. So, for instance, the New York Police Department in the wake of 9/11 actually began to collect foreign intelligence. They started a department within the NYPD to collect this intelligence. Another trend in the United States post 9/11 was the development of fusion centers. Now, fusion centers were data centers where federal and state authorities could begin to look at data, put data together, and find where threats were. Now, this is a very interesting trend here in that it denotes a moment in which the law enforcement apparatus begins to blend and meld with the intelligence apparatus. And the issue of fusion centers becomes particularly salient when we think about the Snowden links and the Foreign Intelligence Surveillance Act. So in the summer of 2013, we know that Edward Snowden released a large set of documents from the National Security Agency to a number of newspapers who promptly reported on those. And we found out a wealth of information about the mass surveillance program that was being carried out by the United States as well as its allies. The UK, Germany was involved. All of these states were engaging in mass surveillance, and not mass surveillance by going out and physically putting taps on people's phones the way that it used to be done. No, instead this was just vacuuming up the masses, the terabytes of digital data that people collect. And so how are they doing this, right? Well, this was all done under the Foreign Intelligence Surveillance Act, which is a United States federal law that allows the government to collect intelligence on non-United States persons. Now, a non-United States person is an individual that is not within the borders of the United States, because within the borders of the United States, the Fourth Amendment applies as a protection against search and seizure. It is a substantive procedural impediment to search and seizure. Foreign persons were also not those that were citizens outside the United States, right? So if you're a citizen outside the United States, the federal courts have held that the Constitution still applies to you. But a non-U.S. person, meaning a non-citizen outside the borders of the United States, was subject to surveillance under the FISA. And under FISA, these individuals had no recourse to challenging that surveillance. Indeed, they may never know that surveillance is going on because FISA was allowing the NSA to collect this data directly from big tech companies. And we know that there were agreements between the NSA and Microsoft, the NSA and Google, the NSA and Yahoo, allowing them to essentially just pull in the data. Now, all of this data then goes into a storage center and is processed. And it is such a large amount of data that I think it is fair to assume that there was some sort of machine learning or AI system being used to sort through this data, to look for those red flags. However, This activity is exactly the same as that is being used in the domestic context. In fact, if a judgment is made on an individual that is outside the United States, that individual could be predetermined to be guilty, to not be innocent, and barred the substantive right of entering the United States. The difference is that the substantive rights in the domestic context give that individual no recourse to this. And we can actually see this in action to some extent. If we think about the Schrems II decision from the European Court of Justice, it was very much based on the idea that under FISA, European citizens have no way of challenging the collection and processing of their data, which is a core right under the General Data Protection Regulation. So we have a real problem at the transnational level as to how rights are being mediated outside of this by a state for individuals that are outside the state. Now, of course, this all sort of circles back in on itself, as one of the other things that we find out from the Snowden leaks is that the processes that had been put in place for this mass surveillance were actually taking in a large amount of data from U.S. citizens and U.S. people or U.S. persons in the language of the FISA itself. So the problem here is one in which we have this really incredible technology, but in the way that it is used by governments against both its citizens and its non-citizens, we have a gap between that technology and the substantive rights that people have been guaranteed. So as a brief conclusion, it's very clear that the introduction of artificial intelligence, machine learning, big data in general into governance structures actually creates a lot of opportunities. There can be a lot of benefits for the citizenry of a state to have these technologies being used by the state. But it also creates a number of risks, specifically in the balance of governance between the governing and the governed, right? And in particular, this risk comes in when there is a lack of transparency in the process. And as the first part of this presentation really dove into, this lack of transparency is about what data is being collected, what data is being processed, and the algorithms themselves that are being used to view that data. But essentially, when this is connected to the enforcement arm of the state, whether it's domestic or it's transnational, we have a risk to individual liberty and individual rights. Now, while the issues that are created differ between the domestic and the transnational context, the promulgation of data, network, and automated processing actually creates unique issues that need to be understood and accounted for within these respective governance regimes. And there's going to be a need for both domestic governance as well as international governance to come to grips with the way in which data and networking and machine learning change substantive rights of individuals.
Thank you so much for your attention and listening to this presentation. We are very eager for your feedback and the discussion.